Next topic I am going to present about is the essential elements of a valid contract. There are certain essential elements for a valid contract, and the first one is competency of parties. That is, the parties to an agreement must be competent to contract. In other words, they must be capable of entering into a contract. So, according to Section 11 of the Act, every person is competent to a contract who is of the age of majority according to the law to which he is subject to, and who is of unsound mind and is not disqualified from contracting by any law to which he is subject. That is, the parties to an agreement must be competent, and if either of the parties does not have the ability to contract, the contract is not valid. The following persons are incompetent to a contract. That is, a minor. A person less than the age of 18 is a minor. And next one is unsound mind person. That is, any person who is unable to understand the term and condition of a contract at the time of its formation is unsound mind. Person disqualified by law to which they are subject to are also not competent to parties. And next one is uh, offer and agreement. Offer and acceptance. That is, agreement which is expressly declared to be void. An agreement to become a contract should not be an agreement which has been expressly declared void by any law in the country, as it would not be enforceable at law. Under different sections of the Contract Act 1872, the following agreements have been said to be expressly void. That is, agreements made with the parties have no contractual capacity. Example, minor and person of unsound mind. Agreement made under a mutual mistake of fact. Agreement with unlawful consideration or object. Agreement whose consideration or object is unlawful in part, section 24. Agreement having no consideration, section 25. Agreement in restraint of marriage, section 26. Agreement in restraint of trade, section 27. Agreement in restraint of legal proceedings, section 28. Agreement by meaning which is uncertain, section 29. Agreement by ways of vaguer, section 30. And agreement to do impossible act, that is section 56. And next one is certainty and possibility of performance. That is, agreement to form valid contracts must be certain, possible, and they should not be uncertain, vague, or impossible. An agreement should be to do something impossible is void under section 26, section 56. Then next one is legal formalities. That is, agreement may be oral or in writing. When the agreement is in writing, it must comply with all the legal formalities as to attestation, registration, etc. If the agreement does not comply with the necessary legal formalities, it cannot be enforced by law. That is, an oral contract is a perfectly valid contract, especially in those cases where writing, registration, etc. is required by some statute. In India, writing is required in cases of sale, mortgage, lease, and gift of immovable property, negotiable instruments, memorandum, and articles of association of a company. Registration is required in cases of documents coming within the scope of Section 17 of the Registration Act 1908. All the elements mentioned above must be in order to make a valid contract. If any one of them is absent, the agreement does not become a contract. And next one is free consent. Free consent means the consent should be free. That is, another essential element of a valid contract is consent of the parties, who should be free. That is section 13. Two or more parties is said to be consent when agree upon a same thing in the same sense. That is, consent is said to be free when it is not induced by any of the following: coercion, misrepresentation, fraud, undue influence, or mistake. When consent means the parties must have agreed upon the same thing in the same sense. According to section 14, consent is said to be free when it is not caused by coercion, undue influence, fraud, misrepresentation, and mistake. An agreement should be made by the free consent of the parties. And lawful consideration. Next one is lawful consideration. Lawful consideration means the consideration must be lawful at the desire of the promisor, promisee, or any other person has done or abstained from doing or thus abstain from doing such act or promises is known as consideration, and it should be lawful. Lawful object. Next one is lawful object. The object must be lawful. The object of the agreement must be valid. And these are all the essential elements of a valid contract.